Good evening. I'm Robert McCorkadale, Director of the British Institute of International and Comparative Law, and I'm delighted to see you all here. Thank you very much for coming for what should be a fascinating, inspiring and innovative talk by the wonderful Lady Mary Arden. And you've got the chair of this is Lord Phillips. Lord Phillips, of course, as you know, was the former President of the Supreme Court and now has the joyous title from our perspective as President of the British Institute of International and Comparative Law. And so we're delighted that he is here to chair this event. A few other announcements. Firstly, thank you from all of us for the sponsors, Nabarro LLP and Shell International. We're very grateful for that sponsorship. We're also thankful for the events team here at BIICL who do a lot of work to put all these things together. I also want to thank those of you who are members and encourage those of you who are not to become members of the Institute. It affords a great deal of engagement with some of our many, many activities, obviously our research, but also our events, our training and our publications. And so without taking any more of your time, I'm delighted to pass you to Nicholas Phillips.
My lords, ladies and gentlemen, good afternoon. Last week, I received a letter from the Oxford University Press. It invited me to a book launch marking the publication of a book entitled Common Law and Modern Society, Keeping Pace with the Change. It added, "We are very proud of this book and would invite you to join us as we celebrate this remarkable achievement of Lady Justice Arden." Well, what you may think is particularly remarkable is that Mary Arden should find the time to write this book when she presides in the Court of Appeal, a duty that most find more than a full-time occupation. But Mary is remarkable in many respects. She's a graduate of Cambridge and Harvard and was called to the bar in 1971. And I have happy memories of working with her at that stage of her career. It's hard to credit, but this year marks the 30th anniversary of her taking silk. She was appointed to the High Court in 1993, assigned to the Chancery Division, and the first woman ever to sit there. 3 years later, she was appointed to chair the Law Commission, a clear marker of academic brilliance. She was appointed to the Court of Appeal in 2000, where she has demonstrated that she has mastered every area of the law that comes before the courts. Between 1998 and 2001, she sat on the steering group of the Company Law Review, whose report was the genesis of that mighty volume, the Companies Act 2006. It certainly was the biggest Act of Parliament produced by that time, and I think it still holds that record. After Tony Blair announced his totally unheralded constitutional reforms, including the proposed abolition of the Lord Chancellor, Mary was appointed by Lord Wolfe to chair the Judges' Council Working Party, which worked on the drafting of the Constitutional Reform Act 2005. And I can testify personally to the huge contribution that she made to this important task. She has sat as an ad hoc judge on the Strasbourg Court and is a member of the Permanent Court of Arbitration in The Hague. International law and international judicial relations is one of her passions, and her appointment as head of international judicial relations for England and Wales was a particularly happy one. And I say that not just because I made that appointment. If you go to a judicial gathering anywhere in the world, I can guarantee that you are soon to be asked, "Do you know Mary Arden?" by someone who has enjoyed and valued her company. Her new book will be an addition to the many works that she has written or to which she has contributed. And this lecture will become one of many that she has given. But it will be a special one among the many, not only because the Grotius lecture is one of the most prestigious in the legal year, but because she has chosen a topic of particular interest and importance. Lady Justice Arden.
Ladies and gentlemen, thank you very much for your warm welcome and also for this invitation to give this lecture. I'm delighted to be here, and I thought I should just start by giving you a roadmap of the areas that I intend to cover. I'm going to start by asking, why do we want a human right to water? Then I'll follow that up with a few statistics. And then I'm going to talk about the human right at the national level, dividing it up between the common law approach and the approach of courts which have constitutional rights. And then I will talk about the human right to water at the supranational level, meaning, of course, the supranational human rights courts. And then you'll get the idea this is a crescendo. And then I'll talk a little about the practical difficulties of allocating water. And then I will move to the international level. And I will talk about the clash between water as an economic asset and its water as a human right. And then the concept of water as a human right as it's now being developed in international law. And then I'll try to state a few conclusions. So that then is my roadmap, and I'm going to start by asking, why a human right to water? Something which many people who saw the title to this lecture asked me. Human rights seem to me to be one of the great ideas of the 20th century. After World War II, first Eleanor Roosevelt, in the Universal Declaration on Human Rights in 1948, and then later the drafters of the European Convention on Human Rights, which I will call the European Convention, in 1950, saw human rights as the way to make our world fairer and safer. But the Universal Declaration and the European Convention are first-generation human rights instruments. They are focused on civil and political rights. Neither the Universal Declaration nor the European Convention provided in terms for a right to water or to air. Yet there are few things more fundamental to human existence. We all need water. There's no substitute for it. There's a finite amount of it. The developed world is using the lion's share of it. And we don't just need any old water. We need clean water to drink, for sanitation, to grow crops, and as a habitat for fish we can eat. And we need safe water to protect us from waterborne diseases. Because many areas of the world are experiencing a shortage of water and humans are having to compete with industry, we need, as I see it, to find ways of expressing the need for a decent minimum water ration for everybody. And in my view, there's no better way than through human rights. The world is becoming increasingly industrialized, but industrial processes also need vast amounts of water. For instance, that glass of beer, which you may hereafter enjoy, takes about 45 litres of water to produce, and a cup of coffee about 140 litres. Industrial processes can also pollute water, and that pollution can lead to general degradation of the living environment for humans and permanent change in our physical environment. The human right to water is an idea, as I see it, whose time has come. And my argument is that with industrialization and climate change, it is increasingly necessary to have a principle of law that everyone is entitled to a minimum amount of water, safe water for drinking, sanitation, and growing food, a decent minimum water ration. And the right to a decent minimum water ration needs to be developed nationally and internationally to do what human rights were always intended to do, to ensure happiness, peace, and prosperity. Winston Churchill proposed a European Charter of Rights in 1947, and he said, and it must be right, it's better to jaw than war. Human rights enable problems to be sorted out in a peaceful fashion. The human right to water must surely be an uncontroversial right, even among the originalists who take the view that the only human rights are those that were already recognized in 1950. For reasons of time and space, I'm going to leave out of account international law dealing with watercourses, and access to water in armed conflict. But now for some statistics, terrifying statistics. The UN states there is a risk that within 30 years, 1 in 4 people is likely to live in a country affected by chronic or recurring shortages of fresh water. According to Water Aid, and I think they're using UN statistics, 650 million people live without safe water today, 1 in 3 people does not have access to proper sanitation, and 900 children a day die from diarrheal diseases caused by dirty water and poor sanitation. Across the world, women walk long distances to collect what is often dirty water. As water shortages increase, water will drive international relations. About 27,000 of the 50,000 rivers in China in 1950 have disappeared. China is unlikely to be interested in Tibet as the home of Buddhism. It wants control of the mighty rivers, such as the Yellow River, the Yangtze, and the Mekong that rise in Tibet. China has to dam its great rivers to have enough water to serve its people and service its industries. It mass produces many of those things which Western societies seem to need. But dams inevitably mean that other countries will have less water. Moreover, sometimes the unforeseen happens when you interfere with nature, desertification. And desertification is now only 13 miles from Beijing, and desertification is also affecting many other countries too. So I move to the national level, and I start, of course, with the common law and how it resolves disputes about entitlement to water, and it's complex. Lord Phillips kindly referred to my recent book, and the basic message in there was about the role of judges and others in keeping the law up to date. I started the book with a chapter called Water Matters. I got the idea for that chapter from the work I was actually doing in the Court of Appeal. I was surprised to find there was a regular diet of cases which, for one reason or another, involved the law of water. So I looked into the law of water and found it both fascinating and complex. Fortunately, the UK and Ireland seem to have plenty of water. It is so plentiful that in Ireland it was provided free until 2014, when a water rate was introduced against considerable opposition. Here in the UK, the problem of not having a decent amount of water has arisen only infrequently in the last few decades, but we've had other problems over the century, and it has been fascinating to find, when preparing for this lecture, that many problems of international law have already occurred in the domestic context. Let me give an example. With the industrialization of Britain in the late 18th and 19th century, there were cases of disputes between upstream and downstream landowners arising out of what the downstream landowner saw as excessive use by the upstream owner, and in some cases, the creation of upstream dams. In Beeley and Shaw, for instance, 2 mill owners disputed the use of water in the River Irwell. The downstream plaintiff complained that the upstream defendant was diverting more water to his mill than he had done previously, thereby depriving the plaintiff of the flow that he was used to for the purposes of his own mill. The 4 judges found in favor of the plaintiff, and 2 did so on the basis of pure adherence to the doctrine of appropriation, treating water as property. First gets it, he keeps it. And that water was left available to be appropriated by successive downstream users. If the upstream user, they held, then increased the amount of water he appropriated, he then interfered with the established first appropriation of those below him, and there was an actionable wrong. So the law was complex, and it evolved first from the appropriations theory, and then, as I shall now describe, towards something called a natural rights theory. This viewed water as a natural resource, and it didn't depend on having a riparian owner who had previously put the water to use in a mill or for irrigation or whatever. The courts were partly influenced by the idea that water was res communis, taking that term from Roman law, meaning public property. Water was residually owned by the public. An example of this was the Privy Council case of Minor and Gilmore. The plaintiff complained the defendant had diverted flow away from his tannery to the defendant's mill. The defendant said the plaintiff had known about the mill before he bought his property and thus could not complain about it. The Privy Council held that allowance had to be made for everyone's reasonable use of water. Reasonable use could not give rise to an action, however, even if it caused actual damage, because there was no evidence in this case that there had been a pre-existing use. So the Privy Council explained that although there was no requirement to show damage, the plaintiff nevertheless had to show that his right had been materially interfered with, and thus the two requirements for an action under the natural rights theory was unreasonable use of the water and a material interference with a right to reasonable use. This particular theory about reasonable use is particularly important in the international context, as two states enjoying a single source of water, let's suppose a river running through both states, may develop their water needs at a different pace. The natural rights theory, if applied, allows for that to a greater extent than appropriation theory could ever do, and led to a balancing of rights. You may be racking your brains if you're thinking about this subject with a vague memory that there was a great case of Bradford Corporation and Pickles, and that it has something to do with this area. Mr. Pickles, you will remember, was a man who lived outside Bradford, which was then developing in the Industrial Revolution, had a growing population. The corporation wanted to have a reservoir. They wanted a source for the reservoir, and they happened to pick on a spring on Mr. Pickles' property. And what Mr. Pickles did was divert the water from the spring and said he was entitled to do that. And he won. And he very much annoyed the Bradford Corporation. But what he was intercepting was subterranean percolating water, which is groundwater, and different rules altogether apply to that sort of water. And it was no part of a defined stream. You couldn't have natural rights unless you had a natural flow. And so the water was not res communis at all in Mr. Pickles' case, and Mr. Pickles could do whatever he wished, which is why Lord Macnaghten spoke those oft-quoted words that you will remember: if the act, apart from the motive, gives rise merely to damage without legal injury, the motive, however reprehensible it may be, will not supply that element. Happily, we don't have to go down that line this evening, but I thought you would like to be reminded about Mr. Pickles. What I am arguing in this lecture is that the human rights narrative, which we now have, gives us the obvious framework for working out water allocation today, where the issue relates to a decent minimum water ration for communities or individuals. Now let's have a look at what the constitutional courts have done. It's India that pioneers the right to water. The first country I have found whose courts recognized a right to safe water is India. India's constitution does not contain explicit recognition of the right to water. However, its courts have for some time interpreted the right to life in Article 21 of the Indian Constitution as including the right to a healthy environment, which itself includes the right to pollution-free water. In rural litigation and the state of Uttar Pradesh, which was known as the Doon Valley case, a dispute arose over mining in hilly areas. The Supreme Court of India, after much investigation, simply ordered the mining work to stop and held this would undoubtedly cause hardship to the mine owners, but it is a price that has to be paid for protecting and safeguarding the right of the people to live in a healthy environment with a minimum disturbance of ecological balance and without an avoidable hazard to them and to their cattle, homes, and agricultural land, and undue affection of air, water, and environment. Subsequently, in Vellore Citizens Welfare Forum and Union of India, and S.K. Garg and Uttar Pradesh, the Supreme Court of India held that the remediation of the damaged environment was part of the principle of the sustainable development, and that the polluter was liable to pay the cost to the individual sufferers, as well as the cost of reversing the damaged ecology. the Supreme Court has tried to keep the balance between ecology and development. In Mehta and Union of India, it held that groundwater was a social asset, res communis again, and that priority had to be given to domestic and agricultural uses over industrial uses, and therefore they did not adopt Bradford Corporation and Pickles. The Supreme Court went on to hold that since water is communal property, res communis, it was held in public trust by the state. The state, as a trustee, is under a legal duty to protect natural resources. These resources are meant for public use, and they cannot be converted into private ownership. The Supreme Court has gone on to develop the concept of public trust to buttress the right to water that it has derived out of the Constitution, and I'm sad that I will not be able to develop that area tonight. But now a brief look at South Africa. South Africa is the only country which I have found whose constitution protects the right to water and which has developed a jurisprudence. Even in the case of South Africa, however, the state does not have an absolute obligation to provide the decent minimum water ration. The right is one which requires the state to act reasonably within its financial resources. Thus, Article 27 of its constitution provides, everyone shall have the right of access to sufficient food and water. The state must take, and in paragraph 2, the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. South Africa has to cope with vast water problems, principally for two reasons. First, water is scarce. Most parts of South Africa are currently experiencing a long, severe drought. Secondly, one legacy of the apartheid era is that access to water supply is extremely unevenly distributed. As such, it is one of the few countries that have specifically recognized the human right to water in its constitution, subject, of course, to the government's practical ability to help. One example from South Africa is residents of Bon Vista Mansions and South Metropolitan Local Council. The residents launched an urgent application for interim relief because their local council had simply disconnected the water supply. The judge held that the matter involved the duty to respect access to water in order to interpret the Bill of Rights, and in particular Section 27. The judge considered international law as stipulated by the Constitution, and in particular relied on the International Covenant on Economic and Social and Cultural Rights, citing the similar language used in both instruments. He concluded that the Constitution must be understood in the same way as under the Covenant, namely that the state must refrain from actions that would deprive individuals of their rights. He found that the applicants had access to water before the disconnection and that the conditions and procedures for disconnection had not been fair and equitable, and that since reasonable notice of termination and the opportunity to make representations had not been provided. So he found that the disconnection constituted prima facie a breach of the constitutional right. As to other constitutions, there are a number which explicitly recognize the right to water, but which haven't, as far as I know, developed it, and they include Ethiopia, Uruguay, Ecuador, and Bolivia. And perhaps I could just mention in the context of national courts, although this is more by way of light relief from the steady diet of water cases, the United States has, of course, many mighty rivers. In the case of U.S. and Millis, the federal courts of appeal had to deal with the question whether somebody committed the offense of depositing garbage in a national park when they went around the national park, which was between I think Arizona and Mexico, for the purpose of depositing sealed water bottles to help migrants who were dying in large numbers as a result of thirst, as a result of coming through the desert. And they were prosecuted for depositing garbage. Well, you'll be pleased to know that the federal courts of appeal had no truck with that, and extraordinary as it might seem, they came to it's not extraordinary. They came to the conclusion that that was simply not to be within the intention of the federal legislature in prohibiting the deposit of garbage. It's an irrelevant point, seeing that the amount of migration which is now facing our own region of the world. In the same way, we would expect local authorities to provide standpipes when travellers come onto the land and are allowed to stay, simply because they have to have water. They have to have access to water. Let's now look at the European Convention. As everyone knows, the European Convention contains a right to life, a right not to be subjected to inhuman treatment, and a right to respect for private and family life. The Strasbourg Court has developed its case law so that the right to private life includes the right to a decent environment. It has done this rather controversially to some minds by using its living instrument approach to interpretation. If appropriate, it might develop the rights further to impose some form of positive obligation on the state to ensure a healthy environment and sufficient clean water. The best-known case in the Strasbourg Court is Lopez Ostra and Spain. Very briefly, this was a case in which the court held there was a violation of Article 8, where the state, Spain, had allowed a waste treatment plant to operate without a license and cause pollution with serious risks to the health of the community. The Strasbourg Court held that the result would be the same whether you analyze the questions in terms of a positive obligation on the state to take reasonable and appropriate measures to secure the applicant's rights, or in terms of an interference by a public authority. The Strasbourg Court therefore left open whether it would develop the positive obligation to which I referred a moment ago. The Court of Appeal in England and Wales relied on this line of authority in Marchik and Thames Water Authority to provide Mr. Marchik with a remedy when his home was regularly flooded with effluent, which the local authority had decided it could not economically prevent. But the decision was overruled by the House of Lords on the basis that Parliament had provided other remedies for this situation. The European Convention usually only applies where the wrongdoer is the state or an agent of the state, but the state may still be liable if the wrongdoer is a private sector organisation, as in Lopez and Ostra, if it can be said that the state failed to regulate the polluter as it should have done. In that case, it failed to ensure that the waste treatment plant had a licence. The Strasbourg Court, in a creative use of European Convention rights to protect environmental rights, has also imposed a positive obligation on the state to provide information, to tell people about environmental risks where they live, and also to enable them to exercise their right to freedom of expression and free association, and so that they can meet and speak about the risks and object to them. This encourages proper democratic decision-making in a state. Moving quickly on, we also have the Inter-American Human Rights Court, which I will call the IAHRC. This has developed the right to personal integrity and the right not to be subjected to inhuman treatment, which are both in the American Convention on Human Rights, to cases concerning prisoners, so as to make it a violation of those rights not to provide prisoners with sufficient safe drinking water. The IAHRC has likewise interpreted those rights in favour of landless indigenous people in Paraguay who were encamped outside their ancestral lands from which they had been evicted and who had no access to clean water other than rainwater. The IAHRC also relied on the right to life, holding that it involved not just a negative obligation not to deprive a person of his life, but also a positive application where the state knows there is a risk to life to prevent conditions arising which impede a decent minimum existence. In the same way, one would expect local authorities here to provide standpipes, as I mentioned. In the jurisprudence of the IAHRC, the right to life has been transformed into a right to a dignified life. Moreover, the state has to take into account the social and cultural value of ancestral lands to indigenous groups. Social and cultural use of water resources is therefore another use of water which may be protected under the human right to water. The IAHRC therefore uses a similar evolutive or living instrument approach when interpreting the American Convention as the Strasbourg Court uses in relation to the European Convention. Then also, I'm not going to mention all the regional bodies, but there is the African Commission on Human and People's Rights. This has also recognized the right to water, and in 1997, it held Nigeria to be in breach of its obligations under the African Charter of Human and People's Rights for allowing contamination of the water resources in Ogoniland. And there are subsequent cases, but I thought you would all recall the case of the people of Ogoni. Now, I was going to mention briefly here before moving on in up my curve to the international scene, just to point out the practical difficulty of establishing priorities in water allocation. This is perhaps best seen between states. The states where rivers drain are likely to be in the best position to control the waters of the river. Other states can only control the flow as it passes through their state, but their activities can, of course, affect the quality and quantity of water that flows to other states. There is a substantial body of opinion in international law that no state is bound to act in the interests of any other state which is a riparian owner. In other words, a state is often regarded as having absolute sovereignty over the waters within its jurisdiction. On the other hand, there is some distinguished support for the theory that a state may not alter the course of rivers within its territory, but the position, alas, is not clear. It may be that the truth lies somewhere between the two positions. Sometimes states can agree to share the benefits of a river, but that is difficult in the case of rivers like the Mekong River, where countries are at different stages of development. One may want to have a hydroelectric power station, while the other may want water for irrigation, as where one wants to build factories or have golf clubs, and the other wants to grow rice, which uses an intense amount of water. In this situation, there has to be some system for equitable allocation of water. The prior appropriation doctrine, that was first in time, first in right, and the traditional riparian doctrine, that water belongs to the riparian owner, are not consistent with the human right to water because they prevent allocation to non-owners on the basis of need. So if there is a human right to water, there will be a huge task to work out what each individual human being in any particular situation should have. At the end of Water Matters, I included a reference to an article by Professor Lon Fuller at Harvard, in which he notes that internationally there was a huge diversity of legal rules affecting the allocation of irrigation water. He said, in actual practice over the history of the world, the most diverse rules have been applied to the allocation of water. These rules expressed every conceivable standard of distributive justice, first come, first served, appropriation theory and Islamic law, to each according to his contribution, Near East, to each according to his needs, Persia, to each according to the needs of society, Persia and Egypt, to each according to the luck of the throw, where else? The British colonies. There's no doubt that the difficulties of allocation is the reason why in some parts of the world, such as the Indus Valley, there are international treaties which determine the allocation of water. The Supreme Court of the United States has, however, developed a doctrine of equitable distribution which is very much worth a mention. When it's exercising its position as the federal Supreme Court, it is, of course, deciding issues between states, and thus its case law is of considerable interest. For instance, there is a case called in Kansas and Colorado, which illustrates how equitable utilization works as between states, and you can apply that to individuals. Kansas sued to prevent Colorado from diverting the waters of the Arkansas River, or if you read it phonetically, it would be Arkansas River. This rises in Colorado but flows into Kansas, whose name suggests that Kansas ought to have substantial benefit from it. The Supreme Court proceeded with a detailed analysis of Colorado's use of the river. It examined the data showing a significant agricultural development of land in Colorado's portion of the river basin and Colorado's dependence on this source of water to support irrigation. The Supreme Court then examined the situation in Kansas. It found that southwestern Kansas had suffered limited detriment in some agricultural areas, didn't suffer as a result of the diversion, that population tables indicated that diversions were not responsible for a decrease in population in the allegedly affected area, and that the statewide agricultural tables showed no marked injury to Kansas due to the diminution of the flow. So, it concluded, when we compare the amount of this detriment with the great benefit that has obviously resulted to Colorado, it would seem that equality of right and equality between the two states forbids any interference with the withdrawal of water in Colorado. So that shows the difficulty of water allocation, of weighing up and balancing. But it does show how allocation could work and the sort of factors that would have to come into account in weighing up the needs of a community versus the needs of development. Let us now go to the international level, and the first area I'd like to cover is the clash between the concept of water as an economic asset and water as a human right. A number of countries, particularly in South America, decided to privatize their water industries, and they entered into agreements providing for arbitration if there was a dispute between the parties in accordance with the 1965 Convention on the Settlement of Investment Disputes between States and Nationals of Other States. This convention is much used by other states. Judge Bruno Simmer of the International Court of Justice said in his Grotius lecture in 2011 that there were then some 3,000 bilateral investment agreements in force involving 170 countries. Under the ICSID Convention, there is an international center for the settlement of disputes. Disputes happen. In particular, in Argentina's case, there were many of them. In one of them, the other party, Vivendi, a water utility operator, argued that by introducing restrictions on the amount of the increase in water charges that Vivendi could make, Argentina prevented it from carrying out its side of the agreement to provide a supply of water. Argentina argued in response that Vivendi had put up the prices so much that people could not afford them, and that interfered with their human right to water. Needless to say, this was challenged as an interference with the right to water. The area concerned was the province of Tucumán. An ICSID arbitration took place. Argentina duly lost, and there is no right of appeal in an ICSID arbitration. All you can do is apply to have the arbitral award set annulled. So Argentina asked for the award in Vivendi's favor to be annulled, and one of its grounds for annulment was that the award disregarded fundamental issues relating to the dispute between the parties, relating to the supply of water as an essential human right. However, unfortunately for Argentina, this annulment application failed. But what is of interest was that there was at that point no reference in the decision refusing an annulment to its human rights argument. The same course followed in a number of other awards. However, Judge Simmer argues in his Grotius lecture that as a matter of policy, international investment arbitration and human rights are not separate worlds, as he puts it. He argues, among other things, that investment protection and compliance with obligations derived from internationally guaranteed economic and social rights may be capable of being balanced, though with difficulty, through interpretation of the agreement, if the obligations of the state are subject to its international law obligations. He refers to newer forms of investment agreements that strike the balance between investment protection and the need for a state to meet its policy goals. And there is now some evidence that ICSID awards are being made which recognize the state's obligations to observe its human rights. And they go on to hold that the state must balance the two sets of obligations, but do so equally. So the human rights obligations does not trump the investment protection obligations, but it is there alongside it. Arbitrators in ICSID arbitrations have dealt with applications by third parties to become parties to ICSID arbitrations. And these third parties are likely to be NGOs and others, and they want to make representations about violations of human rights. However, consistently with the approach to human rights obligations, ICSID rules have now been changed. Originally, the applications were refused, but since the 10th of April 2006, arbitrators can approve the joinder of third parties, provided that none of the parties objects. So there is a chance that the arguments will be put by an NGO or other third party. Now I want to move on to the increasingly high part of the curve, the concept of water as a human right and how it is taking root in international law. I began by saying that the human right to water was not recognized in the first generation of human rights instruments. Likewise, it wasn't recognized in the International Covenants of 1966. However, it was mentioned in the 1979 Convention on the Elimination of All Forms of Discrimination Against Women, which requires states to ensure that women have adequate living conditions, including sanitation and a right to water. Likewise, the International Convention on the Rights of a Child obliges states to recognize the child's right to health and to pursue the implementation of this right, among other things, through the provision of clean drinking water. But as we've seen, the derivation of the human right to water is far wider than the right to equality or the rights of the child. It's also derived from the right to life, and in this Latin American example, from the right to personal integrity, which entail having a healthy environment. That particular penny has now dropped with the international community. Development of the law by domestic courts feeds into the interpretation of human rights by supranational human rights courts, and together they feed into and inform the development of international law. The key instrument is the International Covenant on Economic, Social and Cultural Rights. This treaty does not explicitly mention a right to water. However, the body tasked with the interpretation of its provisions, the United Nations Committee on Economic, Social and Cultural Rights, has since clarified that such a right can be implied. In its General Comment 15, issued in 2002, the committee explicitly recognized the human right to water. In effect, it said that the right to water could be read into Article 11 of the Covenant, which recognizes the right to an adequate standard of living. Importantly, General Comment 15, GC 15, imposed an obligation on states to take steps to ensure the realization of the right to water, or the right to a healthy and adequate standard of living. There's no reference to a human right to water, but there is this reference to the adequate standard of living and the improvement of living conditions, and they must involve the provision of water. Now, general comments are not binding per se, but they carry significant legal weight when the committee has to interpret the covenant, and therefore these interpretations have a significant bearing on the enforcement of the covenant and the realization and enforcement of covenant rights. The International Covenant for Economic, Social and Cultural Rights only imposes an obligation on states to realize rights progressively within their available means. But there is now an international accountability mechanism for the enforcement of the covenant. Until 2013, it was only possible to lodge communications at the international level regarding alleged violations. Now, Article 1 of a new optional protocol, which came into force in 2013, affirms that the committee is competent to receive and consider communications in accordance with the provisions of the protocol. And Article 2 provides that all rights set out in the covenant can be invoked before the committee, Before individuals can bring complaints, they are required to exhaust domestic remedies, but they can bring complaints before the committee. And the optional protocol is in the course of achieving recognition through currently 45 signatories and 21 parties. So that was a step in the right direction by General Comment 15, which emphasized the right to an adequate living environment, and subsequently there was this method of individual application to the committee to enforce that right. But then there was a yet more momentous step in 2010. In 2010, 2 resolutions further affirmed the existence of a right to water and finally cemented its recognition in the international sphere. One was issued by the UN General Assembly and the other by the UN Human Rights Council. The General Assembly Resolution 64292 was adopted on the 28th of July 2010. It was called for by Bolivia. The resolution recognized the right to safe and clean drinking water and sanitation as a human right that is essential for the full enjoyment of life and all human rights. It also acknowledged the importance of equitable access to safe water and sanitation as an integral component of the realization of all human rights. It called on states and other international organizations to provide financial capacity and technological resources to developing countries as part of global efforts to provide safe, clean, accessible, affordable drinking water and sanitation for all. The Human Rights Council followed up with the Human Rights Resolution 15/9, which was adopted on the 6th of October 2010, and it affirmed that the human right to safe drinking water and sanitation is derived from the right to an adequate standard of living and inextricably related to the right to the highest attainable standard of physical and mental health, as well as the right to life and human dignity. Most importantly, it called on states to develop appropriate tools and mechanisms, which may encompass legislation, comprehensive plans and strategies for the sector, including financial ones, to achieve progressively the full realization of human rights obligations related to access to safe drinking water and sanitation. This refers to progressive realization and so uses the language of socio-economic rights. But this is important. Full realization depends on a state's resources. Nonetheless, there may be a core obligation that has to be fulfilled immediately. The need for water is rather more pressing than many other needs, and so surely it cannot be that a state could absolutely refuse to provide any water on the grounds of its resources. In addition, the content of the right has to be meaningful. It's not enough for a state to provide water that is deficient in quality or quantity. To be meaningful, the right has to give an individual the right to water that meets what I would call a 4-star rating. The water has to be adequate in quantity, acceptable in quality, accessible and affordable. And the reasons for those 4-star rating is self-evident. Respect for the right to water will also include action of different kinds. It may include an obligation to protect the water sources, to fulfill human need, and even in some circumstances to procure a supply of water, and in all cases to make it affordable and accessible, and to provide necessary information about water resources to the communities affected. Neither the resolution of the General Assembly nor of the Human Rights Council are legally binding. Nonetheless, their adoption reflects an international trend in recognizing the human right to water. And the HRC resolution bolsters General Comment 15's claim that the right to water derives primarily from the International Covenant on Economic, Social, and Cultural Rights. And soon, the right may become recognized in international customary law. Customary international law depends on a consensus of civilized states, which is only capable of proof by usage to be obtained from the action of nations in similar cases. and in similar cases in the course of history. So it's important to ask whether the right to water is part of customary international law, because if so, it would mean that states who are not bound by the right, who've not signed up to the various covenants, nonetheless would be bound by the human right as a matter of customary international law. Courts are entitled to look at a broad range of sources when determining what the customary international law is, and those sources include decisions of the International Court of Justice, UN materials such as General Assembly resolutions and declarations of the General Assembly, declarations and publications of state departments, and decisions of national and international courts. The courts may attach different weight to different sources. General Assembly Resolution 64292, which I referred to a moment ago, received 122 votes in favour, with only 41 abstentions, no votes against, and 21 states absent. The wording is important. It states that the Assembly recognises the right to water, which is tantamount to acknowledging an existing right, not creating a new one. The same approach was adopted by the Human Rights Council. There have been similar political declarations, but not all of them analyse the right identically. Furthermore, there was in 2004 the influential Berlin Rules on Water Resources Law, issued by the International Law Association. They state that following General Comment 15, there cannot now be much doubt about the existence of the right to water, but this may be on the optimistic side and placed too much significance on human rights instruments rather than on other sources of customary international law. But all these things do indicate that the right to water is not far away, and this is especially so in the light of the last development to which I will now turn. You might be thinking that the right to water must have reached some anticlimax after the 2010 resolutions, but that the contrary is the case. Last September, the General Assembly adopted the 2030 Agenda for Sustainable Development. This marks a major step forward in the right to water. The 2030 Agenda for Sustainable Development is different from the previous Millennium Development Goals. It includes new Sustainable Development Goals, and these include the right to water and sanitation as a stand-alone goal. Goal number 6 acknowledges the risk that within 30 years, 1 in 4 people is likely to live in a country affected by chronic or recurring shortages of fresh water. It then sets out 8 water-related targets to be achieved by 2030, which explicate what the human right to water may ultimately involve. And I'll just read 1 or 2 of them. The goal is to achieve universal and equitable access to safe and affordable drinking water for all, to achieve access to adequate and equitable sanitation and hygiene for all, to improve water quality by reducing pollution, eliminating dumping, and minimizing the release of hazardous chemicals and material, and so on. So there is a current UN initiative, the 2030 Sustainable Development Goals, which is aimed specifically at ensuring that everybody has the right to water. In 2016, the UN Secretary General and the President of the World Bank jointly announced their intention to form a new panel to mobilize urgent action towards the Sustainable Development Goal for water and related targets. This decision comes as an explicit attempt to address the forecast that I have mentioned, and also to address the problem of water-related disasters that we read about so often due to climate change. In the words of the Secretary General, Ban Ki-moon, water is crucial to realizing the Sustainable Development Goals, which at their heart aim to eradicate poverty. And so I turn to my conclusions. Why has there been this rush to categorize the right to water as a human right? When I started this lecture, I stated that human rights provided the obvious framework for use today. And there are many reasons for that, but I will pick out just 3. First, by analyzing the law in terms of human rights, the law can turn the focus on the vulnerable individuals with the greatest need. Second, human rights empowers people. Everyone has a human right, so that everyone has the right to speak up about his entitlement and to be heard. So the analysis encourages and it strengthens democratic society. Thirdly, if water is a human right, it can be enforced through the UN human rights system. The narrative has moved away from implying the right to water from other rights to seeing the right to water as a human right in and of itself. And as I've said, rights are empowering. Through the UN system, they provide a means whereby defaulting states may be called to account. They also provide material on which regional and national courts can draw in order to find rights and remedies where people have been deprived of a decent minimum water ration. And I draw these conclusions from the developments that have so far taken place. First, the developments in international law have undoubtedly been the result of pioneering work of courts in countries such as India. Two, the right to water is in bud and it's about to flower. In the light of the 2030 Agenda for Sustainable Development, it seems likely that with the growing recognition of the importance of the fair distribution of water, that before very long, customary international law will recognize the right to water. And in this regard, I would note the separate opinion of Judge Weary-Mantry, who made reference to the inference of a right to the environment from the right to health and the right to life in a recent case involving Hungary. Thirdly, if customary international law recognizes the human right to water, then following Judge Simmer's line of reasoning, the right to water will also have an important impact on the conduct of states trying to effect major infrastructural changes, and on the decisions of international lenders and investors. Fourth, the recognition of the right to water could make a huge contribution in the settlement of international disputes and proper water management worldwide. Instead of fighting over water, the law should be developed to contribute to the proper distribution of water and help reduce the mismanagement of water and pollution and contamination. And finally, fifthly, the human right to water could be the start of a new world order. Its recognition could lead to a change of cultures where human life is under threat. All this talk of water must maybe making you very thirsty, but I would remind you that tomorrow is World Water Day. That's entirely coincidental, but it is World Water Day. So the world, we are told, should go blue to celebrate. Wear blue, paint yourself blue, or even whistle the blues. Certainly, the developments in the law have been real and momentous, and it's been a privilege to try to explain them to you. Thank you.
Gentleman here would like a microphone.
My question is this. How in national law would you see the human right to water developing? I can understand the point that an individual might have a right against the state. Give an example of somebody whose home was flooded and so on. But how would the court balance the right of the individual against the right of the state? How far would it go? How would the court balance the right of the individuals against other individuals? How do you see this developing, particularly in national?
Thank you very much. The problem of balancing the rights is one to which the courts are becoming very accustomed as a result of the Human Rights Act. And that's really why I spoke about Kansas and Colorado, because it shows the depth into which one might have to go in order to balance the rights. But that all depends on the level of deference to which you give the decision maker.
Thank you again for that tour de force. I was wondering if you can elaborate a little bit on your view about creating a new international order. Certainly water is starting to play a larger role in creating some sort of oil and water community in the Middle East narrative, including some discussions about the Red Sea, Dead Sea Red Dead. But that also does assume that water has a larger geopolitical dimension, which contributes to sustainability, other sustainability measures such as agriculture, food, and so on. And balancing those, I suppose, rights or essentials are also a difficult act to balance. Thank you.
I think you are absolutely right to say that the right to water, that water has a geopolitical implication and aspect to it. And there are some frightening statistics about the number of wars that are started simply because one side needs more water or needs better access to water. They want to take a bit of territory because it gives them access to water, and so on. When I said that, that the right to water might lead to the creation of a new international world order, I was simply postulating that human rights might go higher up the agenda, and that it might become the case that customary international law would give them greater prominence, and so that states would be bound to comply with them, so that there would be more talk about human rights than people going off and fighting.
I just wondered, in an international aspect where, in terms of international development, for a while there's larger companies that have been purchasing land that has a large amount of water on it. How would that work when a country doesn't necessarily have the legal system in place to sort of respond and balance those needs between the individual and the company?
I didn't quite hear all the question. Which system are you referring to?
Sorry. So in developing countries where the legal system isn't sustainably developed enough, maybe to defend the individual right of water against maybe a corporation's right of business, how would the international community react to that in a legal stance? If that makes sense.
Well, the sort of channels that I was talking about in the lecture are where the individual complains either to his own court or to a regional court, which might be the African Commission, for instance, the African Court of Human and People's Rights, or straight to the UN. And what is important about the recent changes is that there has been an individual right of access to the UN's Human Rights Council given. But hopefully, the individual will be able to go to his own court, and if its own court sees sufficient jurisprudence from countries like India enforcing the right to water in the most striking situations where development is challenging the existence of long-established and ancient peoples, then hopefully the local courts will be inspired to develop the human right within their own constitution.
One more question near the back.
Good evening. I was wondering whether you thought that the approach of the Committee on the Covenant on Economic, Social and Cultural Rights to deriving the right to water from the right to an adequate standard of living has diminished the impact that such a derivation might have had on the regional systems and how they go about protecting the right to water, inasmuch as the right to an adequate standard of living is not protected under any of the regional human rights instruments. And if I might, whether you thought there was any other way around it, because that certainly represented a turning point. So,
yes, but that's a very interesting thought and a most helpful intervention. But the regional courts are not prevented from using their own rights to life or their own rights to protect personal integrity, to develop a right to water. I haven't talked at all about people's rights, and clearly that's another field altogether that might be involved in the enforcement by the regional court of rights. I don't see the UN's work as diminishing in any way what regional courts are doing. In fact, I think that all these bodies inform and nourish the work of each other.
Right, well, I think it's probably the moment to move on to some refreshment, which is at the end of the room. We are, I'm sure, all very grateful indeed to Mary Arden. Certainly for myself, I don't think I've ever been to a lecture which has left me with so much to think about, and quite a lot of it, I think, is absolutely terrifying. One extraordinary statistic that it takes 140 litres to produce 1 cup of coffee. Thank you for not telling us how many litres are necessary to produce 1 glass of wine, or that might have been inhibited. Our enjoyment was to come. But could I ask you all once again to thank Mary very much.